Good day. We're going to report labor law and social legislation. Here's our team. The first reporter is Benerjan Bulisay. The second one is Princess Merdilin C. Magbitang. The third one is Janine Alcantara. And the fourth one is Vincent Abesamis.
Introduction. What is labor? In its limited concept with the term labor refers to physical or mental exertion necessary to produce goods. In its broader concept, it may include the labor force who are employed or those who are able and willing to work but are temporarily or involuntarily unemployed. In short, labor is physical activity or force which is used in making or doing some work. What is labor law? It includes all the rules of law governing the condition under which person may work under the control of other person called employers. The term may also refer to labor standard and labor relation laws governing hours of work, weekly the rest period, minimum wage rate, unfair labor practices, strike and lockout. In other words, in law, are designed to look more on the immediate result of employer-employee relationship. Sa madaling salita, labor law, it is the responsibilities and right of an employer and employee. It includes working condition and wage laws. What is social legislation? It is a law governing the employer-employee relationship while the latter is not at work due to hazard arising from employment. In the other word, social legislation is a protection and promotion of right to avoid discrimination in society. Labor law and social legislation distinguish. We have 5 labor law and social legislation distinguish and significant differences. First one, labor law is more direct in its application as it affects directly actual. Social legislation governs the effect of employment such as compensation for injuries. Second one, the former is designed to meet the daily needs of a worker. For social legislation, the latter involves long-range benefits. Third one, the former covers employment for profit or gain. The latter may cover employment for gain or non-profit. Fourth, the former affect work of the employee while the latter affect the life of the employee. And last is benefits. Under the first are paid by the worker's employer, while the second are paid by government agencies administering the program such as Employees Compensation Commission.
I am Princess Merdilin C. Magbitang and I'm going to report the purpose of labor legislation. Purposes of labor legislation. It is a tourism that because of economic superiority of capital labor as a factor of production is weak succor from the state. So ito po ay upang harapin ang mga problemang nagmumula sa katayuan sa trabaho at individual. Dahil dito, may mga problema gaya ng mga oras sa trabaho, sahod, kondisyon sa pagtatrabaho at iba pa. Ito ay naging pangunahing paksa ng batas. Labor legislation is therefore intended to protect the worker from the stronger and to correct the injustices that are inherently present in the employer-employer relationship. Sa madaling salita, ito ay distribute ng mga wealth para maprotektahan yung mga exploitation. So this is to help protect employers while ensuring that neither is to subject to unfair treatment or exploit. Source of labor law, primary and auxiliary. The first one is Philippines Constitution. The second one is passed by the Congress. Third one is decision of Supreme Court. Fourth one is implementing rules and regulation of Department of Labor and Employment. The last one, decision of quasi-judicial bodies. Note that the CIR was replaced by the NLRC but the CAR was abolished by Batas Pambansa 129 and its function transferred to the regional trial court. The second includes: number 1 is opinion of Secretaries of Labor and Employment and Justice. The second one is report, debates, hearing made and conduct by Congress. Third is labor law reviews. Fourth is labor law and social legislation textbook. Fifth is opinion of legal luminaries. Sixth is foreign law and decision. And seventh is business magazine. Hello, Engineer Michael Angelo Magbitang. I am Princess Merdeline C. Magbitang, student of Nueva Ecija University of Science and Technology, and I would like you to have a short interview about labor law and social legislation. Can you explain legal framework for employment legal relationship?
The Labor Code primarily governs labor standards and labor relations and regulates first pre-employment. So this includes the recruitment and placement of overseas workers and the employment of non-resident foreign nationals. Second, we have the human resources development. So this includes training for apprentices and learners. Third, we have the labor standards. So this includes the hours of work, rest periods, wages, and premium pay. Fourth, we have the health and safety and social welfare benefits. Fifth, labor relations, including regulations on the organization and activities of unions, collective bargaining, and strikes and lockouts. And lastly, the sixth, we have the post-employment. So this includes termination of contracts and retirement.
Can you explain the principle of equal rights?
The principle of equal rights is based on to ensure all people, and in the context of workplace, all employees have the right to receive the same treatment and not to be discriminated regardless of a worker's position, age, disability, gender, race, and religion.
And what is the effect of collective agreement with respect to persons?
The collective bargaining agreement will be the law between the employer and the employees belonging to the bargaining unit. Since the rights and obligations of both parties are contained therewith, then the violation of such will give rise to a cause of action before the labor arbiters.
Hello, good day everyone. My name is Janine Alcantara and our report will be all about law on labor standards. Labor Code. The Labor Code is defined as the Charter of Human Rights and a Bill of Obligations for every working man. It is designed to be an institution for national development. Ang Labor Code ay nagtatakda ng mga patakaran para sa pagkuha at pagpapaalis ng mga pribadong empleyado. Ibig sabihin, bawat worker merong terms and conditions sa work including maximum work hours and overtime. Employee benefits such as holiday pay, 13th month pay, and retirement pay. Ibig sabihin, may mga karapatan yung bawat manggagawa na dapat sundin ng may-ari ng isang kumpanya na naayos sa batas. Basic feature of the new labor code. One of the salient features introduced in the labor code is the purging of laws with built-in leverage for graft and corruption. Anti-graft precautionary provisions are injected to provide and maintain industrial peace and harmony in the working world. Means that the labor code ay nag-i-improve depende sa pangangailangan ng bawat manggagawa, kaya mahalagang ito ay ating nalalaman upang maiwasan yung panloloko sa mga manggagawa. Mahalaga rin na keep reviewing your policy, conduct a risk assessment, and understand the law and other regulations. The Labor Code introduced the following reforms. A. Emancipation of labor relations. When we know the labor code, hindi tayo magiging alipin ng policy na gusto lamang ng kumpanya. To free from restraint, control, or the power of another, especially to free from bondage emancipated the slaves. B. Transportation of workmen's compensation. Nagbibigay ng mga benepisyo sa mga empleyadong nasugatan o nagkasakit if you are harmed in a workplace accident. Tinitiyak nito na yung mga injured workers may makukuha ng pangangalagang medikal at kabayaran para sa kita na nawala sa kanila habang hindi sila makabalik sa trabaho. C. Abolition of the permit system. The services of an employee who has been engaged on a probationary basis may be terminated kapag siya ay nabigo na maging isang regular na empleyado alinsunod sa mga katwirang pamantayan na ipinaalam ng employer sa empleyado sa oras ng kanyang engagement.
Good day everyone, my name is Vincent Jebisamis from BSCE 3A, and I will be continuing the report D. Placing the government corporations under the civil service. Basically po, ang sinasabi lang po sa D ay lahat daw po ng government corporations such as every branch, agency, subdivision, and instrumentality shall be placed under civil service. For example po, ang GSIS, since government-owned corporation siya, classified na po siya under sa civil service. E. Creation of Overseas Employment Development Board and National Seamen Board. Ang law po na ito ay ginawa para sa mga kababayan natin na mga nasa ibang bansa, such as OFWs. The main purpose of this code is to give protection sa mga OFW natin. Later on, na-abolish yung dating code at nire-organize noong 1982 under former President Ferdinand Marcos administration para sa development ng employment opportunities as well as the protection of workers at para na din ma-promote ang industrial peace. Pero ano nga ba ang industrial peace? Ito po ay yung ideal situation para sa industrial growth dahil po ito ay nag-establish ng warm and friendly labor management relations sa employers, employees, at pati na rin sa government. F. Incorporation of Agrarian Reform. 5 days after the proclamation of martial law, former President Marcos issued Presidential Decree No. 27 or the Code of Agrarian Reform of the Philippines. This only applies on private agricultural land devoted to rice and corn under shared tenancy or lease tenancy. The purpose of this law is to promote social justice, whereas enabling him to essentially wipe out the landlord-dominated Congress. The Agrarian Reform under of DAR or Department of Agrarian Reform, sila ang nagpapatakbo at nagpapatupad pang pribado man o pang publiko. It gives the tenant the rightfully owned or deemed owner of the land that he tilled. There is a limitation under DAR. Maximum of 3 hectares if irrigated farm and 5 hectares if unirrigated farm. Yon ang mapupunta sa DAR, then ibibigay ito ng DAR sa mga magsasakang walang lupa. All in all, the landowner may retain an area of not more than 7 hectares. But under tenant emancipation law, it doesn't mean automatic ang pag-transfer of ownership to the beneficiary or the tenant farmers. The tenant farmers will have to pay in full or in amortization of the land for the period of 15 years. No title of the land owned by the tenant farmers will be issued until full payment of the land. The land transfer of Presidential Decree is affected by 2 stages. Number 1. Certificate of Land Transfer. It refers to the qualification of the land tenant farmers and complies certain conditions preparatory of the ownership of the land. Number 2. Emancipation Patent. It refers to the farmer beneficiary absolute ownership over the landholding issuance of an original or transfer certificate of title to his name. This will be cancelled in the following grounds: abandonment of the land, misuse of the land, failure to pay 3 annual amortizations, misuse of financial and support services, sale, transfer of conveyance of the right to use land, illegal conversions of the land. G. Updating of all labor in social legislations. As mentioned physically, the book is divided into 7 books. But in summary, it's all about the updates in all labor and social laws. including the women and child labor laws, apprenticeship laws, and industrial safety laws, are updated in the code to align with national development priorities centered on social justice and human dignity. Construction in favor of labor. The labor codes provides that all doubts in implementation and interpretation of the provisions of this code, including its implementation rules and regulations, shall be resolved in favor of labor. Sinasabi lang po dito pag meron pong doubts or pagdududa, dapat daw po ma-resolve ito in favor of labor. Yan lamang po. Thank you.